Imagine being charged with murder. You tell everyone you acted in self-defense, but the prosecution doesn't buy it and you find yourself facing a first-degree murder charge. 2 years later, a 5-hour audio recording enters the chat and the prosecution drops the whole case. When people do the most, I do the analysis. Let's go. Now hold on before anybody starts saying, see, she was innocent the whole time. That's not exactly what happened, but something clearly changed. Because prosecutors went from saying we have a solid murder case to essentially saying, wait a minute. This evidence creates reasonable doubt about whether this was actually criminal.
I spoke with that mother. She said that her daughter, LaToya Crabbe, told her husband, Curtis, earlier in a couple weeks before this happened, that she wanted a divorce. She believes something happened in the family home that caused her daughter to pull the trigger, but she believes her daughter did so out of self-defense.
So today we're discussing LaToya Crabbe's case out of Manassas, Virginia. We're going to talk about what happened between LaToya and her estranged husband. We're going to look into why prosecutors initially believed that they had a first-degree murder case. And what was it about this 5-hour recording that changed the prosecution's position? Because, hoo-wee baby, this case took a turn. Let's rewind to October 21st of 2024. Police were called to a home in Manassas, Virginia. Inside that home was 36-year-old Curtis Bryant Crabbe. He'd been shot and he died at the scene. His wife, 34-year-old LaToya Christine Crabbe, was arrested.
Martin says one of the red flags came after she served Curtis a 30-day notice to vacate the home. She says her son confronted his brother-in-law about not taking care of his children.
She came to me that night and said, why did he say that? Are y'all trying to get me killed? And it took me back, and I'm like, whoa, she's never used that language.
And it's very important to note that LaToya didn't deny shooting Curtis. Her position was that she shot him in self-defense. And that's what makes this case so interesting, because we're talking about someone saying, yes, I fired the gun, but there was a reason that I believed I had to. LaToya and Curtis Crabbe were an estranged couple. They were about to go through a divorce. The defense said that there was a lot of documented conflict between the two of them.
There was a point where I almost thought I should have just let him kill me.
LaToya's family also pointed to messages allegedly sent by Curtis that they said contained threats against LaToya and members of her family. Some of those messages involved threats to hurt the family and even to burn down their home.
Martin says the second red flag came 2 days before the shooting, when Curtis allegedly sent her daughter a series of text messages that read in part, answer my call or I'm going to go to the house and punch your mother in the face, followed by, I will hurt everyone in that house, then set it on fire, and finally, I'm taking the kids. You will never see them. Martin says her daughter was experiencing domestic abuse.
Why didn't she do something? But she did.
Now, before you fix your mouth to say, well, he threatened her, so obviously she was justified in shooting him. That's not how this works. Not legally. A threat can be important evidence, but it doesn't automatically make a later use of deadly force legally justified. You get what I'm saying? The circumstances surrounding the shooting itself still matter. It matters a lot, actually. What was happening? What did LaToya reasonably believe was happening? And most importantly, what does the evidence show? That's where this case gets extremely complicated. Prosecutors didn't see it the same way. Initially, they weren't buying the whole self-defense argument. LaToya was charged with second-degree murder and a firearm offense. And prosecutors pointed to physical evidence that they believed told a different story. One of those issues involved the ammunition and the number of shots fired. Prosecutors argued that the evidence suggested LaToya had reloaded the firearm during the shooting. And obviously, if you're trying to prove this was an immediate defensive reaction, the idea that somebody stopped, reloaded, and continued firing can become very significant in a self-defense case.
LaToya Crabbe arrested and charged with murder in October. LaToya Crabbe was arrested and jailed October 21st after Manassas police say she shot her estranged husband multiple times in the couple's bedroom. Crabbe's defense attorneys say the fatal gunfire came just days after Curtis Crabbe allegedly sent threatening text messages. One reading, "I'm not playing around. I will hurt everyone in that house, then set it on fire." LaToya says she acted in self-defense. Her attorneys say Curtis cornered her holding a knife. She says behind bars, initially in solitary confinement, she felt hopeless.
But here's the thing. The defense disputed that claim. That's right. They argued that the prosecutors failed to establish that LaToya Crabbe actually reloaded her weapon. So again, we have two very different interpretations of the same evidence. And that's something I want y'all to keep in mind throughout this story, okay? Because we have a criminal case that's more about whether evidence exists. It's about what that evidence means. And then the case got worse for her. By January of 2025, LaToya had been indicted on second-degree murder and a firearm charge, but prosecutors later pursued something much more serious. A grand jury returned a first-degree murder indictment in March of 2025. So now we're talking about an allegation of premeditated murder. And prosecutors also raised questions about Ring camera footage that was entered into evidence. Prosecutors alleged that LaToya had deleted footage after the shooting, and they argued that her actions could be evidence of premeditation. Of course, her attorney disagreed with that interpretation. And again, this is where the case gets really interesting. Because imagine being LaToya Crabbe. You've been saying this whole time, "I was protecting myself." But then the prosecution comes along and essentially says, "No, we think you planned this." Those are two completely different scenarios. And if this case had gone to trial, a jury would have had to sort through all of it. The prosecution ended up offering LaToya Crabbe a 15-year plea deal, which she turned down. But then something changed. Now we get to the part that made me stop and say, wait, what? Because investigators were preparing for trial when they were finally able to access a recording that had not been previously examined. And this wasn't some little snippet of audio. Oh no, it was approximately 5 hours long. 5 hours.
Nearly 22 months later, prosecutors dropped her murder charge.
I just wish they would have did the right thing in the beginning.
LaToya and her mother, Marilyn Martin, always maintained she'd shot Curtis in self-defense. He'd been threatening, they said, after she asked for a divorce. The night of the shooting, LaToya claimed he tried to attack her in the basement, the rest of the family upstairs.
If she had not shot him, she would have been dead. Those children would have been dead. He would have definitely killed me. She definitely saved our lives.
But prosecutors didn't buy that defense, at least not initially. Now, though, they say they've decrypted a 5-hour-long audio recording off of LaToya's laptop from that night.
The recording captured conversations and events that took place immediately before the shooting, and prosecutors reviewed it. They also reviewed the transcript, and after doing that, their position changed. I'm talking big time.
We were going to go get a restraining order the next day. So she wanted the recording to back up us getting a restraining order.
Prosecutors didn't say specifically what was on the recording, just that they can't now ethically continue to trial. Marilyn told me she's not heard it yet, but was told what's on it.
You could clearly hear him threatening her and opening the knife, and he's coming towards her, and then you hear a shot.
That recording contains significant evidence that a reasonable jury could interpret as supporting lawful self-defense. And that very same evidence created reasonable doubt concerning criminal intent. Now, this is where I want to make sure we're being precise. The prosecutors didn't say that the recording proves that LaToya was innocent. They didn't even conclude that she acted in self-defense. What they essentially said was this: there's now enough evidence that a reasonable jury could believe that LaToya Crabbe acted lawfully when she shot and killed her husband. And listen, that's a huge problem for a murder prosecution, because the prosecution has the burden of proving intent. They're the ones who have to prove the case beyond a reasonable doubt. If there's credible evidence that now creates reasonable doubt about whether a defendant acted criminally, how do you ethically continue? How do you continue to argue that this was murder and not self defense? Well, apparently the prosecutors decided they couldn't.
Marilyn doesn't understand why it took so long for investigators to decrypt the file, but said she believes it sends a clear and dangerous message.
To the survivors, you don't have the right to fight.
Now, should any additional evidence change their mind, prosecutors could try to recharge LaToya. Understandably, she was not up for an interview tonight, but her mother told me she is focused now on healing from this trauma, taking care of her 3 kids, and working to get her job back.
And there's something I want to point out about the 5-hour recording. It wasn't a barrage of footage from the past showing the character and aggressive behavior of the deceased. It was a single recording that led up to that exact moment that Curtis Crabbe was shot and killed by his wife, LaToya. So once again, the conduct of the deceased does matter. And it's very relevant to the facts of this case. Curtis's conduct, it narrowed a thin line between murder and self-defense. So they dropped the charges. On August 14th of 2026, prosecutors moved to enter what's called Nolle Prosequi. And if you're sitting there like, Nikki, what in the world does that mean? Don't worry, I got you. That's just a big old fancy but legal way of saying the prosecution is choosing to not move forward with the charges. That's when we start to see the headline saying murder charges dropped. And that's fine for a headline, but I want us to understand the difference. This is not the same thing as LaToya Crabbe went to trial and the jury said not guilty. There was no acquittal because there was no jury verdict. The prosecution chose not to continue with the case. And based on current reports, that doesn't necessarily mean the charges can never come back. So please don't turn this into the court proved she was innocent, because that's not what happened. What happened is actually a lot more interesting than that, because it means that the prosecution's own assessment of the case changed after reviewing new evidence. I view it as the legal system actually working as it should. Innocent until proven guilty, right? No one's saying that LaToya Crabbe is innocent, but the prosecution didn't prove her guilty. And that's the part I keep thinking about. Just think about how much happened before that recording was accessed. LaToya was arrested and she claimed self-defense, but prosecutors disagreed. They questioned the number of shots. They questioned whether the firearm had been reloaded. And they even raised questions about the Ring camera footage. The case escalated to first-degree murder. And LaToya spent months behind bars before being released on bail. And then a 5-hour recording enters the picture, and suddenly prosecutors are doing a complete turnaround. They dropped the entire case and concluded that they now have significant evidence that could support LaToya Crabbe's self-defense claim. That's a pretty dramatic shift. But what was actually on the recording? I know y'all would want to know that. What was on that tape? And I get it. And that's the question that I want answered too. But here's what we do know. We know the recording was approximately 5 hours long. We know it captured conversations and events immediately preceding the shooting. We know prosecutors reviewed it. And we know they said it contained evidence supporting a possible lawful self-defense interpretation. But until the actual contents are publicly released, or at least reliably described in greater detail, we shouldn't just make up the rest. Because that's how true crime commentary goes sideways. You have a few confirmed facts, and then somebody fills in the blanks, and 5 people repeat the speculation. And then suddenly the speculation becomes what actually happened. No, let's stick to what we actually know. And honestly, what we know is pretty interesting if you ask me. Let's listen to what LaToya's mother said was on that recording.
You could clearly hear him threatening her and opening the knife, and he's coming towards her, and then you hear a shot.
Now here's another question. Does this mean that the prosecutors were wrong? If prosecutors ultimately decided the evidence wasn't strong enough to continue, does that mean they were wrong for charging LaToya in the first place? I don't think we can say that necessarily because prosecutors make decisions based on evidence available to them at the time. Then sometimes evidence changes. Sometimes new evidence is discovered. And sometimes, like in this case, digital evidence gets decrypted or accessed, and this can take quite some time to finish. And then the picture changes. And when it does, prosecutors have a legal obligation to reassess the case. They can't just say, well, we already charged her, so we have to win this case. No, winning shouldn't be the main goal. The goal is supposed to be justice. So if new evidence makes the prosecution question whether criminal intent can be proved beyond a reasonable doubt, walking away from the prosecution is actually the more responsible thing to do, both legally and ethically. But let's not forget Curtis. We can get so focused sometimes on the defendant that the person who died disappears from the conversation. Curtis Crabbe died. A family has suffered a loss. Regardless of whatever happened inside that house that day, the loss of life is real. And acknowledging evidence that supports LaToya's self-defense claim, it doesn't mean that we have to celebrate Curtis's death or turn him into a villain. We can acknowledge the tragedy while still examining the evidence. Those two things can exist at the same time. The new evidence created reasonable doubt about criminal intent, and on August 14th, prosecutors moved to drop the charges. So what we can honestly say about this case is this. The people responsible for prosecuting Latoya Crabbe immediately concluded that newly available evidence made the case too uncertain to continue. That is a major development, and it's also the message you'll be delivering when you share this video.
Virginia is
Virginia
not a
is not
stand your
a
ground
stand your
state.
ground state, okay? Let's get into what that means. Since there is no stand your ground law in Virginia, in some situations there will be what we call a duty to retreat. So let's get into what that means. So a duty to retreat means that if you can safely avoid using deadly force, then the law expects you to do just that. As a matter of fact, the law says that you have a duty to retreat to the wall. And the wall is as far away from the threat as possible. So deadly force is a last resort, not a first response, okay? Now, you do not have to retreat if retreating would put you in danger. So the question is always going to be, was retreat safely possible? And guess who determines that? The finder of fact, aka the jury, or the judge in some instances, but most people opt for a jury trial. So as with every rule, there is an exception. So here's the exception to this rule. There is no duty to retreat in your home because your home is your castle. This is the castle doctrine. So inside your home, the rules are a little different, okay? You don't have to flee your own house to claim self-defense.
If you enjoyed this video, please give it a thumbs up and share it with someone who can use this message. Subscribe to the channel if you haven't already done so, and leave a comment down below letting me know your thoughts. Do you believe the prosecutors made the right call, or do you think this case should have proceeded to trial? Meet me in the comments. We can continue the conversation there.